here to talk about how important it is for attorneys to be aware when they're representing someone in a personal injury action of a fairly complicated area of law that is recently emerged, and that is how to assess what someone could be liable for in terms of medical damages. If you're on the hook for any of the injuries that you have caused, we've all seen the size of those medical bills and how quickly they get out of hand. We also, in this kind of insurance age, are well aware that what you're billed and what your insurance company eventually pays are two really different numbers. You know, for example, you're in the hospital, let's say, for a weekend, and the bill is $100,000. Your insurance company is going to settle that for maybe $20,000. And the way the law used to work is that if you were liable for injuring someone, you would eventually maybe owe them that $20,000. But just this last year, in 2009, there was a case in the Fourth Circuit, Howell versus Hamilton Meats. And the court there decided the woman who was injured, as soon as she signed her admission slip at the hospital saying she'd be liable for any bills incurred, she took on the liability for the full bill. And whatever her insurance company settled out for was their business. But that the person who'd injured her didn't just owe what they finally paid, but whatever the hospital billed, no matter how excessive those fees are in light of the way insurance works right now. This is the area that gets really dangerous when you're representing a client in a personal injury matter. How do you protect them from those exorbitant bills and those damages that never really exist, that no one's ever paying? No one goes back to that sample case and pays that $80,000 in the middle. It just disappears. But somehow, under Howell, your client could owe that money to the plaintiff when no one ever pays it. The Supreme Court for the state of California did decide on March 9th to review the case, which is great news for defense attorneys because it's depublished and it can't be cited anymore. The difficulty now is plaintiffs' attorneys, judges, clerks are citing the language from Howell as if it's still valid. And so you have the law technically on the side of the lower bill, of the reduced insurance payment bills. But in practice, it's not working that way. Attorneys are having motions denied, subpoenas quashed, and the reasons the judges are giving, or that they're hearing from plaintiffs' counsel, all involve language from Howell, which technically isn't good law. The complication now is we wait a year and a half for the Supreme Court to decide what they're going to do. Are they going to go to the high side of the billing? Are they going to go low side? Are they going to find a reasonable balance in the middle? But until that's figured out, any attorney who's dealing with personal injury cases doesn't just have to know what the law looks like on paper, because that's not the way it's been playing out, but has to know what those plaintiffs' attorneys are going to be trying to get admitted into court and how to respond to that. And more important than that is, once you know that, being proactive about it. You can't just wait till the end of the trial.